We're going to go ahead and get started since we're running a little bit late. Thank you all for coming. We're just going to give a few comments before we hand it over to the panelists.
All right, so first off, welcome to the Stanford Technology Law Review's 2014 Symposium on Privacy Challenges in the Internet Age. So my name is Anna Sahlstrom. I'm the editor-in-chief of the Technology Law Review, or STLR as we call it for short. So STLR is an entirely student-run academic journal at Stanford. In addition to hosting symposia like this one, we publish three issues annually containing IP and other technology-related scholarship. All of our articles are available online at STLR, that's STLR.stanford.edu. We're also, of course, on Twitter at StanTechLRev, which naturally is our Blue Booked journal name. So if you're interested in receiving 3 emails a year when STLR publishes new issues, as well as invitations to future symposia like this one, you can subscribe on our website at stellar.stanford.edu. So with that, I'd like to hand it off to Jia Wang and Lincoln Lowe, STLR's fantastic symposium editors, who have both put together a lot of insight and legwork in assembling an amazing event today, as well as dealing with all of the logistics required to make it happen. So thank you to all of you for attending, and with that, I'll hand it off to them.
Hey everyone, as Anna mentioned, I'm Lincoln Lowe. I'm one of the symposium editors, and every year we try to choose a theme that's relevant to practitioners in the area. And privacy is something that's come up year after year, and it's only been recently that a lot of companies have started paying attention to it full-time. They have privacy people in-house, they have privacy people at law firms now. And one of the big things we wanted to do is cover a wide range of different issues. The first panel we have is on Ecpa, and it covers a lot of the government intrusion things that we've been hearing about in the news. The second one we have is internet torts, and that's an issue that I think is really interesting because it hasn't fully been settled. We hope that both these panels will be really informative and you'll actually be a little bit entertained. I think our panelists are going to be great. There is the Cal-OPA panel as well in the afternoon, and we hope you guys stick around for that. If you guys have any questions or concerns, feel free to come up to us and ask.
And I'm Jia Wang, the other symposium editor. So I just want to go over a few logistic things really quickly. So each panel is an hour and a half, and since we're starting about 10 minutes late, just kind of mentally keep in mind move the times 10 minutes later, basically. And after this panel, we're going to have some more coffee and tea set up outside. So we'll take a very, very short, 2 to 5 minute break just to go, use the bathroom or grab some coffee, whatever you need. And then we're going to take a lunch break, probably around 12:40 now. So just keep that in mind. And finally, if anyone wants CLE credit and hasn't signed in yet, make sure you go up to the front at the registration tables and put down your email and your bar number. All right. Thank you so much for attending. And I'm just going to go ahead and hand it off to the first panel. So Susan, if you want to go ahead and start.
All right. Well, thank you so much, Gia and Lincoln and the editor-in-chief there for inviting us to the symposium. It's delightful to be here. And I'm Susan Freiwald from the University of San Francisco, and we have a great panel set up today. And I'm going to start off, our panel is on reform under the Electronic Communications Privacy Act, or as we'll refer to it from now on, Ecpa. Before I start, I just wanted to ask the audience here, how many of you have learned something about the Ecpa provisions in the past? Okay, so the rest of you, okay, so it's about half or a little more than half haven't. And those of you who've learned about Ecpa in the past, do you feel like you're very familiar with it? How many people feel like they're very familiar with Ecpa? Okay, so it's, okay. It looks like there's only about 10% of the group are very familiar with Ecpa. So I think I need to spend some time just giving some basic background about Ecpa, which was what my plan was. So basically, we're going to be talking mostly about Ecpa reform that's making a significant headway in Congress. And Mark is going to talk about, Mark and Nicole are going to talk about the reform efforts. And Dominique is going to talk about some areas that may be the subject of reform in the future. But Ecpa itself is a law that Congress brought into being in 1986, and it is designed to cover basically wiretapping and interception of electronic communications as they transit or as they're moving, email as it's moving, the acquisition of stored email and associated attributes. That's the second part of Ecpa. And then a third part, which is called the pen, register, and trap and trace provisions, which is also designed to cover the acquisition of what are called communication attributes, or what now we think of as metadata, information other than the contents of communication in transit. So there are three parts of Ecpa: the interception provisions, the stored content and attributes provisions, and the metadata provisions. Now, the metadata provisions, although they're very much in the news, metadata is very much in the news because of the NSA and metadata program. Those are not the subject of reform, and we're not going to talk about those today. The interception provisions, which have to do with intercepting content of emails and maybe the content of other kinds of electronic communications, those are also not the subject of reform efforts today. But Dominique is going to talk about those when she has her part of the discussion, because they may be the subject of reform in the future, because right now there are a lot of class actions brought by plaintiffs' lawyers claiming that when companies engage in such things as behavioral tracking or scanning your emails, when Google scans the content of your emails, that constitutes an interception under the Electronic Communications Act. It's kind of like a modern-day wiretapping of your communications, and then that should subject these companies to significant liability, and it could, as Dominique will discuss, be liability in the billions, or at least $1 billion. So that may be something that's subject of reform in the future. But the reform efforts in Congress today, and what we're going to focus our discussion, what Nicole and Mark and I are going to focus discussion on, is the reform of the Stored Communications Act, which is the second provision of Ecpa. And the Stored Communications Act governs acquisition of the contents and other associated information of electronic communications stored by a service provider. So your stored email on Google, stored records with a service provider. And what happened is in 1986, Congress decided to try to clarify the protections for that information. And we have to laugh because it came up with a scheme that has turned out to be extremely complicated. And so basically, and I don't want to go into too much detail, but I'll go into enough detail so you can see why it needs to be reformed. Congress differentiated between we can think of email, but obviously there are other kinds of content information that's stored, like information you would store in the cloud, right? Documents you would store in Dropbox and the like. But what Congress said is when you store a document, when you store your email, if you store it for less than 180 days, it's your private communication, and it should be protected from law enforcement acquisition by the protections of the warrant requirement. When you store it longer than 180 days, the thought was you've abandoned it, and you don't care about it anymore. And so it's okay to protect that with a lesser standard, like a reasonable suspicion standard. Now, hopefully you can right away see that doesn't really make sense today, right? Because today, if we keep our emails, particularly because it doesn't cost anything to keep them, we keep the ones we keep are the ones we care about the most, right? The ones we want to, depending on your email hygiene, usually we keep in our folders, right, the ones that we care about. So that's just one example of how the scheme they came up with doesn't really fit modern day practices. So that in itself is kind of weird and complicated, that it depends on the level of protection against law enforcement acquisition. In other words, what kind of process does law enforcement have to give to Google when they want to acquire email? Depends, and the level of the standard hurdle they have to overcome depends on how long your email is. That's one weird thing, okay? But because the statute has all these weird terms in it, like electronic storage and remote computing service, there's many more levels of complication. For example, the Justice Department has argued, basically with success everywhere except the Ninth Circuit, that once a person has opened or accessed or retrieved an email, that email is no longer subject to the higher protections of the less than 180 days rules. They're no longer subject to the warrant protections. They're subject to this reasonable suspicion standard or maybe even a subpoena standard. And with a subpoena, law enforcement doesn't even have to get the oversight of a judge. So now it's not just it's not just 180 days, but it's whether you've opened or accessed or retrieved it. With, again, email that's been opened, accessed, or retrieved, subject to less protection. And again, that's not intuitive. It just has to do with a reading of the statutory terms. And then there's one additional layer, which is, again, reading the statutory terms. If your email is stored on a provider that does not offer email to the public, for example, if your email is stored on a university system or a private company system, so if your company provides email but only to its employees and not to the public, then the Justice Department takes the position that if you've opened, accessed, or retrieved your email, then it is no longer subject to the protections of Ecpa at all. And so there's this, so if you, for example, were to read the DOJ's manual on this, there's this matrix of all these different factors. And for me as someone who's been studying in a long time as a privacy advocate, when I get to the part that says, a whole bunch of email, namely any email read or opened or retrieved on any system provided by a university or corporation falls entirely outside of the protection of the Electronic Communications Privacy Act, I think something's wrong. And so that's in itself a reason that I think a lot of people are interested in reform, that it seems like there's just a lack of coverage. And then the other thing that spurred reform is that in 2010, we finally got a decision after so many years of using email. We finally got a decision from a federal appellate court, which is the Warshak Court in the Sixth Circuit, that said that the Stored Communications Act is unconstitutional to the extent it permits access to stored email with less than a warrant. And so that was great news I actually worked on the amicus brief for law professors, so I was very much pushing for that. It was great news for privacy advocates. It only applies in the Sixth Circuit. And other circuits have yet to join on, but that's also fueled the push for reform. And so we have one circuit saying it's unconstitutional. We have the Ninth Circuit rejecting the 180-day distinction. The other thing that is sort of adding uncertainty, but also maintaining some higher level protection, is several companies, and I know Google is one of them, as a matter of practice is just saying, I don't care about all these different rules. As a matter of practice, we're going to require a warrant from law enforcement before they can access communications. So with all that, and I will let Mark take over, although I have a few more things to say about sort of what's going on in Congress in terms of reform, but that's why there's been a push to just let's level out protection at the level of a warrant for access to communications in storage. We should have a higher level. It should be even. There's one more factor I haven't discussed, but it's equally complicated, and that's whether or not and when law enforcement has to give notice to the target. Obviously, you don't want to give notice before you've conducted surveillance, but when you have information in storage and you can issue what's called a preservation order to the provider, you can give notice to the target so that the target, the subject whose emails it is, without risking that you're going to lose the information, right? If the information's already there, but a lot of times in practice, law enforcement does not give notice. So all of those things are up for reform. I just want to say there's a number of things that are not the subject of reform. For one thing, there's no movement to get a suppression remedy, which is a pretty, I think it's a pretty big omission, because the Wiretap Act passed in 1968, which covers interception of phone calls and bugging, has a suppression remedy, which means that if someone is improperly the subject of a wiretap investigation, in other words, law enforcement doesn't follow the rules, they can bring a motion to have the information that's gathered that way excluded from trial. And so there's a really big incentive then to bring such motions and to litigate the issue and to develop law on the subject. And the Ecpa doesn't have, never had a suppression remedy for any of its provisions. And that's just because that's what the Department of Justice asked for in 1986. And as a result, there are very few cases under Ecpa. Because the cases that do tend to be brought are civil cases. Because if you're a defendant and you're facing going to jail, the prospect of getting $10,000, it's not that important, right, as compared to going to jail. So without a suppression remedy, we're not going to have the law development that I think we really should have. Another thing that's not covered by the reform proposals, although a few bills do, but they're not getting anywhere near the traction, is changes to the location data rules, the cell site location data rules. So we have some different decisions in the appellate courts. There's an incredible lack of guidance about whether access to cell site location information requires a warrant. And again, I've worked on some of those cases. I'm happy to discuss more, but Ecpa says nothing clear about it because cell sites in 1986 were tiny little babies, baby industry. So that it would be nice to have some clarity there, although some states have started to provide it. And the last thing, besides the information that Dominique is going to talk about, the Ecpa reform efforts, and by the way, they've been, and I'm sure Mark will talk about this, have been sort of pushed a lot by the Digital Due Process Coalition, which has had a lot of its momentum brought by companies, has not had on its agenda any discussion of the issue of companies disclosing a lot of records information without any restriction. So that's part of the law now, that companies can disclose any non-content information without any restriction as long as they don't disclose it to the government. And there's no restriction on that in Ecpa, but there was no appetite for changing that. Okay? So that is the issue. Those are the issues as I see them. I would now happily turn it over to Mark Jaycox, and I apologize for not introducing my panelists, but since there's such a nice write-up in the program, I thought I would skip that step. So Mark?
Cool.
Thanks,
Susan. So, Susan has described kind of the oddities of Ecpa and why it needs reform. I'll just speak, quickly and add a small addendum to that and say that, one of the things and one of the issues with Ecpa is that I like to bring forward is, emails on your computer. If you were to print out the same emails that were on your computer and lay them on your desk, right, it would have a Fourth Amendment probable cause warrant standard if the government ever wanted to seize it. Solely because those emails are in your computer and older than 180 days seems bizarre, right? This doesn't seem like it actually translates. And, that's the one thing I would add to kind of Susan's great introduction about Ecpa, how confusing the statute is with its definitions and how old the statute is, right? It's a 1986 statute. And so I'm going to talk mostly on legislative reform efforts and where we are. And so, I'll start with saying that EFF is part of the Digital Due Process Coalition, DDP, and it's a very diverse coalition ranging from small companies to large companies across political ideologies, and I think I think we reached over 100 a few months ago, and so it's a pretty hefty coalition. We've been pushing for Ecpa reform for quite some time now. I think maybe 5 years or so, 5 or 6 years. And so right now in Congress, every year for the past couple years, there has been Ecpa reform bills presented. It's been an issue. It was highlighted, especially in Warshak in 2010. And we've kind of seen these bills come and go. We've seen them move slightly, but never even get out of committee sometimes. And this year, and kind of the past year too, we've seen a highlighting and an exuberance towards updating Ecpa. And updating Ecpa, as Susan said, only in the confines of this warrant for content. And my shorthand is essentially warrant for content is kind of my shorthand for fixing this 180-day rule and updating Ecpa when it comes to the SCA, the Stored Communications Act. And so right now, you have a few competing bills. I'm going to start with the Senate because Senator Patrick Leahy from Vermont is on the Senate Judiciary Committee. He was actually on the committee when it first passed, when Ecpa was first drafted and passed. He was a junior senator from Vermont under Senator Mathias. But so Senator Leahy has been around for a long time. He knows Ecpa needs to be updated. He has been a stalwart advocate and someone who has been pushing to update Ecpa. And so yet again last year, or this congressional cycle last year into this year, he introduced the Ecpa Amendments Act with Senator Mike Lee from Utah. And this is a clean Ecpa bill. It's a clean warrant for content bill. And we saw it for the first time, I believe in a couple of years, it got out of committee. It was something the Judiciary Committee fully agreed with. It was something that everyone was okay with and willing to get it out of committee. And it's a very big first step when you get something out of committee, because once something is passed out of committee, right, it can go with the assent of the majority leader, it can go to the floor for a full vote. So we we jumped over the one hurdle of the Judiciary Committee, and in a unanimous vote too. There was no there are no nays on that vote. Everyone agreed that this is an old law. It's a law that needs updating, and something's got to be done about it. It has to be done. The second hurdle now is getting it to the floor. And where we are right now, I don't know if people have been following the news on this, it's been getting a decent amount of press, is that where we are right now is some agencies are upset with Ecpa reform because they feel that the lower threshold subpoena is okay, and that with a subpoena you should be able to access and get access to the content of your emails and content of other private messages for purposes of civil criminal investigations. And one of the most outspoken agencies that we've seen, and is the object that has been getting a lot of news, is the SEC. And so the SEC has kind of come forward as an agency, the agency to fight for and to kind of fight for an exception in Senator Patrick Leahy's bill for civil agencies. So you would have a bill that expresses a warrant for content in the criminal context, but you would have it's still undecided how this would be worded, but you would have some sort of civil agency exception for when the civil agency shot off a subpoena that, as opposed to the criminal side of things, they would be able to get that content. And the SEC has started to fight for this because it was clear that Ecpa is moving, and I think Ecpa, some sort of Ecpa reform will probably pass this year. So we've seen this fight emerge in the Senate, and the SEC Chairman Mary Jo White has been very good fighting for it. She's gotten at least some of the Republican senators on the committee to voice the concern, and this concern has essentially stalled Senator Leahy's bill in the Senate. And there are ongoing negotiations trying to figure out if the SEC even uses this, right? We've tried to look at past investigations and things like that, and press releases, and trying to see, well, when is the SEC actually using this? And it comes up very rarely. We've only seen them at least publicly acknowledge a couple of cases, and so this is an ongoing debate in the Senate now. Kind of a politics 101 is that when it's stalled in one house, you go to the other, right? You fight as much as you can in one house, you see where it goes, and then you either try and leverage the other house or you see what happens in the other house. And that's kind of the strategy, and at least what we're seeing now. We've kind of DDP, EFF, and others have switched to the House. And the House is much more sympathetic to a clear bill, a clean bill, and a warrant for content bill. And it's actually been refreshing because in the House, there is a companion to Senator Leahy's bill. But what we've seen is representatives, especially from the Republican Party, from the Tea Party, they essentially disregarded Senator Leahy's bill and proposed their own bill. And this bill is the Email Privacy Act, and it's by Representative Kevin Yoder, Mark Graves, and Jared Polis. And so what they've done, none of them, this will come into play later, but none of them are on the Judiciary Committee. And so what they did is they kind of proposed this clean bill with no hint of civil agency exceptions, and a very, just a strong bill, a good Ecpa bill that codifies Rorschach, fixes the 180-day rule, and should be passed by Congress. And we've seen this bill. This bill was passed at the middle of last year, and from then until now, in part due to a lot of the activism efforts, lobbying and other things by DDP, it just got over 200 co-sponsors, right? And the magic number in the House is 218. And so what's going to pass a bill. And so what's happening now is we're seeing kind of this Email Privacy Act gain and become a steady force and gain a tremendous amount of momentum. And it's great to see, because the more co-sponsors this bill gets are clearly the more votes it will get. And once it hits 218 co-sponsors, it's essentially 218 votes. So you have this bill, you have these two competing bills. Now, to move a bill in the House, I don't know how many parliamentarians we have here, but to actually move a bill in the House, you have to get the permission from the chairman of the committee, right? And so the committee that has purview is the Judiciary Committee, and the chairman is Representative Goodlatte from Virginia. And Representative Goodlatte has purview over this, and is debating right now, as we speak, is debating about, does he take this fantastic bill that has over 200 representatives, or does he try to come up with his own bill? Susan mentioned some of the things that aren't in this bill, right? These bills only deal with the warrant for content. They only deal with the SCA. They don't deal with geolocation. Bless you. They don't deal with geolocation. They don't deal with other things. And so this is kind of the item right now that Representative Goodlatte is dealing with. There's these two competing bills, and everyone is trying to figure out, well, how do you get it? Will you bring forward the Yoder-Graves bill, is the Email Privacy Act, or are you going to create your own bill? And so, the advocates right now are pushing for the Yoder-Graves bill. I mean, this is a bill that has over 200 representatives at 201. I have no doubt that it will get to 218, and once it gets to 218, we'll all wait and see about what exactly happens. And we hope, and we're encouraging the chairman to take up that bill, and we'll see what happens. That's kind of the layout of where we are, in the Senate with these, the Senate and the House with these two bills. And the Senate, again, as I said, is kind of still stalled, and then you have this bill in the House gaining a tremendous amount of momentum.
All right, well, thank you very much. That was really interesting, and I hope people are coming up with good questions to ask, because we're going to have plenty of time for questions. And now we turn to Nicole Jones from Google, who also has a background as a prosecutor, and we look forward to your comments.
Thank you. So yes, I'm Nicole Jones, and I just want to selfishly take 1 second to say that I'm an SLS grad. I was recently at a panel at Berkeley, and when I was on a panel and everyone else said they were Berkeley grads and everyone cheered, and then I was SLS and no one said anything, so I just wanted to get that out there. So as Susan mentioned, I am a former federal prosecutor, and I work specifically on cybercrime and national security cases. And now I work for Google, and I work on law enforcement and security type issues, including handling issues related to data disclosure. Google is a member of the Digital Due Process Coalition and has been very active and vocal regarding the need to reform Ecpa. My supervisor, Rick Salgado, who actually wanted to be here today but couldn't, has testified before Congress on this issue more than once. It's very important to us. The other providers in Silicon Valley are also equally supportive of reform. But one of the things that I think is important to remember is that Ecpa was actually and is a privacy statute. It was enacted to restrict the disclosure of data, restrict law enforcement's ability to get this data. It was a very unique statute at the time. As a prosecutor, I can tell you it's one of the few statutes that has these types of restrictions, which is what confuses law enforcement, causes them to be very nervous anytime there might be any talk of change. But when you think about Ecpa in the context of it was intended as a privacy statute, and it was very forward-leaning at the time. If you think about it, in the 80s, people were not talking about privacy. Normal people hardly used computers or email. And the 180 days distinction that is so confusing to us now, that people laughed when Susan said that Congress was basically thinking you'd abandoned your email. At the time, that's how it worked. If anyone remembers using email then, you didn't keep it up with the provider. You connected your modem and it whirred for a while. You accessed your email, downloaded it physically to your computer, and then disconnected your ridiculously slow modem. You didn't stay online the whole time. There was not value in keeping your data up with the provider. You downloaded it. So really at that time, 180 days was eons in terms of leaving your data with the provider, which is just simply not the case now. The reason that I brought that up is mostly to just say one of the major things to think about when you're reforming statutes that or drafting original statutes that have to do with technology is to try to remember to keep them technology and platform neutral, because you do not know what the situation is going to be like in 20 years. And apparently in the 80s, we were able to pass bills through Congress, and now it is much more difficult. So we're stuck, and we have been stuck for years with a statute that bears no resemblance to the way we currently use the technology. So I think that's one of Google's and the Digital Due Process Coalition's major points is to not put these restrictions that have to do with the way technology works now. And working at Google now, I see that you're constantly 5 steps ahead. The engineers are thinking of things that, don't even make sense to me at all right now. But so we don't want legislation that's going to restrict that, and we also don't want to leave big holes that are going to be difficult to fill in people's privacy expectations. So Google is very supportive, and as a practical matter, search warrant for content is the standard right now, and it has been since Warshak in 2010. Google and all of the providers, basically, as soon as that opinion came out, I was a prosecutor at the time, so I got a different set of emails. But my understanding at Google, the second Warshak was published, there were emails, we're changing now, search warrant immediately. And that's been the case. And the sky has not fallen. Prosecutions are going forward. Investigations are continuing. So I think that's an important thing to keep in mind. And in fact, even the Department of Justice has finally admitted it. I think in one of the last hearings, there was finally a statement of, okay, we finally admit the 180 days no longer makes sense, which is huge. They had been reluctant to say that, but as a practical matter, it had been applied to them for years at that point. And no prosecutor, even though Warshak technically only applied in the Sixth Circuit, and I don't know if there might be just one provider there, all the providers had applied it, and prosecutors were not risking their cases by going into trying to get this data without a search warrant, and they've continued to be able to prosecute their cases. So I think that's important to keep in mind. I began as a prosecutor in 2006. And that was well before Warshak, well before Theophel, which Susan also had alluded to, which sort of cast some doubt on what it meant to be in temporary storage. And I will not bore you with that because it's very confusing. But there had already started, by 2009, there had started to be some questions about this distinction and whether you needed a warrant. And even then, and I only one time used a subpoena with notice to obtain email data. In every other case, it was a search warrant, and that was our recommendation in our office. And I was in the Southern District of California pretty much the entire time I was prosecuting cyber cases. So, and there's reasons for that, practical reasons. You're generally interested in more recent emails anyway, so it makes more sense to go through the extra effort and get your search warrant. There are issues with notice. Generally, when you're in an earlier stage of investigation, giving notice might not be the right thing to do for your investigation. There are delayed notice provisions. Those can be unwieldy to work with as a prosecutor because you have to keep remembering to deal with delay. And so that's another point to bring up is notice. Notice is something that the providers are also very interested in giving. Most of the providers want to be able to give notice to their users when legal process is received. And the reason for that is users are better positioned to know if they have objections that can be raised and to pursue their rights than the providers are. Most of the providers, Google included, we review all legal process very carefully to make sure that it does comply with the law and our policies before disclosing, but it is important, notice provisions. One thing that's interesting about the way Ecpa is written in terms of notice is it had delayed notice provisions that were limited in time, how long you could delay notice. But on the search warrant aspect, or if you get a 270B sealing order for your process, there's not time limits associated with that. So that's maybe one of the things to consider. And I'm not aware that that's actively up.
Say it again, the time limits on the period that you can
get. Time limits on a 270B sealing order. Which is an interesting thing to maybe think about in addition to some other changes to Ecpa that maybe aren't currently on the list. But in terms of what's currently out there, Google is fully in support of the search warrant for content. Very important. It's also Susan brought up location information, and Google isn't a telephone company, so things like cell site aren't an issue for Google, but there are other issues with location and GPS and geolocation data that are unclear under the current law, and is one of the principles of the Digital Due Process Coalition is to also make clear what the legal requirements are to obtain different levels of precision in geolocation data. And as a provider, precision and clearness in the law is very important, and more important than I had even realized as a prosecutor. It's very difficult for global providers to be in a position of having unclear laws, and we receive legal process from all of the districts, all the federal districts, all the states, and we're constantly on state prosecutors, for example, that maybe don't deal with cyber issues very often, have no idea Ecpa even exists. And it's very difficult for us right now to be like, oh no, under Ecpa, we can't give you emails without a search warrant. And then they go and read it, and they're like, well, that's not what it says. And then you're like, well, but if you read Rorschach, and then also if you read Theophil. So it's now that I'm on more of a compliance side, I can tell you that even though as a practical matter, everyone requires search warrants, getting the law changed to actually say that would be incredibly helpful. And I think those are the big things. Another thing that I might mention that is also mentioned in the digital due process principles that isn't spoken about very often is the pen register trap and trace statute, which is an interesting statute. I think there's more attention paid to it now, sort of post-Snowden era, but it's an interesting statute that's sort of in conflict in terms of its standards with Ecpa in that, and not to get into the details of PRTTs, but there's information you can get real time with a very, very, very low showing that you can't get after the fact stored without a higher, not much higher, but still higher level of showing under the SCA. So those sorts of tensions in the law, it would also be great to have those ironed out so that there's consistency in terms of the data type without so much focus on the when and the how.
Great, very good. Thank you so much. Lots of stuff to ask questions about and that we can elaborate on. All right, great. Dominique.
Well, in preparing for this panel, Susan and all of us were talking, and I thought I'd kind of bring up the next gen or the next sort of generation of issues with Ecpa that companies are facing. Just in full disclosure on my background, I'm a privacy partner at Alston and Bird, and I do represent a number of companies that are grappling with statutes like Ecpa to figure out compliance outside of the criminal context, but actually in the civil context. So all of the things that you've heard here on the panel today as it relates to criminal, companies face in the same sense as it relates to civil subpoenas. So Ecpa reform is important, and many of our clients are part of the due process and diligence project because they want to make sure that they have good relationships with their customers and their users, and they're seen as being protective of privacy. A second issue that comes up that's not really in the DDP reforms or any of the bills that we've discussed, but actually turning over that data of emails or stored communications in connection with civil discovery can open up a company to class action lawsuits. And why is that bad? I mean, for certain big companies, if you take a Comscore, a Google, or a Facebook, it's not that the resources aren't there, but it's also a brand issue. It's important for these entities to show that they are protective of privacy. So to have it splashed that they're just giving out data of their users related to civil subpoenas are troublesome and have landed certain companies way back in the day. I started my practice in 91, but years ago, in 98, worked on a number of class actions that companies like Yahoo and others faced when they got civil subpoenas and they had to decide whether to actually turn over information about the not only just emails, but also identity of users. And when they made those decisions and kind of weighed whether to protect privacy of the user or to comply with the civil order, they sometimes complied with the civil order only to find themselves landed in, class actions all across the country. So having seen it sort of from the ground that way for many decades, that's an area that I know that companies are really interested in getting clarification. And these same decisions that we're talking about here in the criminal context do come up and do get cited in these civil cases. And sometimes the case isn't about just an email. There's just discovery that somebody wants to get in the connection with online, defamation or cyberbullying or so forth. I've definitely seen these requests being made, and all of a sudden a company getting pulled into litigation. So that's one issue. Separately, and kind of another thing that I think will be on the horizon, certainly not in Congress right now, but is on the brains of a number of companies and thought leaders, is what to do about these older statutes like Ecpa, enacted, as Susan said, in 1986, that are being used now by the plaintiffs' bar to sort of shoehorn in new technologies into these old statutes. So one of the things that we're starting to see back in 2010, a heightened awareness, and even before Snowden, just a creeping awareness of users that behavioral tracking for purposes of targeting ads or creating products that are customized to users are becoming more and more ubiquitous. And starting in 2010, we saw a couple, I would say 17 behavioral tracking class actions, many of them relying on the Stored Communications Act or other parts of Ecpa as the basis for those claims of accessing and tracking the user's behavior without their consent. So that was in 2010. Fast forward to today, where there's over 212 behavioral tracking, do not track class actions pending across the country, most of them filed in the past 18 months. And the damages that are being sought under the Stored Communications Act, which is part of Ecpa, as we've discussed, at $10,000 per violation on the civil side, can be extraordinarily have extraordinary repercussions for companies, not just from an exposure standpoint, but also just from a brand standpoint and also shareholder standpoint. For example, ComScore, which is involved in doing a lot of the analytics for the websites that you probably all visit. If any of you have Ghostery and you download Ghostery onto your Chrome, you can see the various Google Analytics, Adobe Omniture, ComScore, and Scorecard used to analyze what's going on a site. Those ComScore just got sued a couple years ago, and a class was certified at 10 million user class at $10,000 per violation, opening up a $1 billion exposure in the Northern District of Illinois for this publicly traded company. And then in June 11th of last year, the Seventh Circuit affirmed that decision, making it the largest privacy class action that we are aware of under any statute in the country. So it's not that ComScore maybe cannot shoulder a $1 billion exposure, but there's also the brand, there's other considerations as well as shareholder issues these days that are coming up more and more in privacy contexts, where for publicly traded companies, when there's a significant exposure, the need to have that exposure disclosed in public filings like the 10Ks and 10Qs, and really getting a handle on what the exposures are really difficult for companies when they're deciding, look, is this just an attempt by plaintiffs to shoehorn these activities into old statutes and it's not a material piece of litigation, or is it something that we really need to disclose in depth? If you come out with a huge, a class certification, which doesn't mean that their liability is there, but certainly establishing that a class will exist at that magnitude, it raises issues as it pertains to shareholder actions and so forth and exposure for board members. So the whole issue of privacy, and that's why I'm so glad that G and Lincoln and everyone who's involved with today, decided to put this on the radar screen, is really becoming a C-suite issue. It's an issue that boards and officers, not just compliance officers, but CEOs are more and more being drawn into as their brands get propulsed in these high-profile situations. So that's really all I wanted to say. None of this is really in any of the bills yet, but stay tuned and look out for this in the next couple of years.
Great. Well, thank you so much. So before I open it up to questions, but maybe people can start coming up to ask their questions, I just wanted to see if anyone on the panel wanted to react to anybody else on the panel. And I will start by just elaborating a little bit on the issues that Dominique just raised, which is really interesting questions about whether or not these practices that the companies are engaged in count as interceptions. And it's just a fascinating question from a kind of from an academic perspective. Obviously, there's a lot of money involved, but from an academic perspective, there's questions of whether or not when a company sort of goes in and sort of maybe grabs a URL that a user is sending to a website in order to figure out what it's doing, is first of all, is the company grabbing content, and is it in real time, and is that an interception, and is that something the Wiretap Act should cover, and what counts as consent? There's some interesting articles in the literature right now about what if there's the company is using some technology to grab content, but that content is never seen by a person. Does that count as an interception under the Act, or should a person have to actually see what's grabbed in order for it to count as an interception? So, and then there's other questions about, is this something that the Ecpa statute should cover, or is the Ecpa just not the right tool for this? Because we're kind of talking about, in a way, tortious behavior that should be kind of fact dependent, and Ecpa is an all or nothing in a way. It's $10,000 yes or no, and maybe we need something a little more fact-dependent. And then lastly, a really big question that we are obviously facing in the future is terms of service, right? Because in these cases, it's often a question of, will have the terms of service or the privacy policy adequately disclosed to the user that this kind of thing is happening. And for example, if you look at the Google scanning case, before the decision by Judge Koh, the Google's privacy policy and terms of service said, we're going to be scanning, we're going to be looking at your content, but that was in a sentence that the next sentence was, we're going to make sure there's nothing like sexually inappropriate. And so Judge Koh said, well, that's not enough to indicate that you're going to be scanning in order to do behavioral tracking and user profiles. And there was some other phrase that was like, we're scanning for, we're going to be looking for viruses and sort of other stuff. And Judge Koh said, well, that's not specific enough. And so right after the lawsuit was filed, I think Google went in and we're going to be scanning your emails so that we can track you and make behavioral profiles. And that's happened across the board with these lawsuits. But there's still a question whether, because we all know nobody reads privacy policies, should that really be enough still to count as consent? And so interesting questions about that will be coming out of these 200 lawsuits that are now going forward. So does anybody else on the panel want to comment on what other people have said or react to what other people have said? Mark, you were an early speaker. Did you have something that you needed to talk about? Dominique, did you want to respond?
I actually had a question. I had a response for you, but I also had a question for Mark. You think that it's likely that reform will go through in Congress this year and that we'll have a new Ecpa bill? Did I hear you correctly?
I think so. Well,
I
think I'm loud enough.
Okay.
Am I loud enough, guys? I think so. We've just seen the momentum gain and increase, especially since I dislike comparing, or at least talking about post-Snowden disclosures and the pre and post-Snowden worlds. And Ecpa is entirely different than the NSA and the intelligence surveillance laws. Like, these are two entirely different legal regimes, two statutory regimes. But the one thing that is undeniable about the Snowden disclosures is the heightened awareness of privacy. Right, it's something you can't deny. Polls are just coming out that are showing that people are changing their behaviors online after these disclosures and after learning about it. A lot of the things that the intelligence community is doing, and so I think my response is definitely yes, and that's optimistic. generally, a lot of people are pessimistic when it comes to Congress, especially this Congress and potentially future Congresses. But I think that there is such momentum. These bills, especially when the House bill. I mean, one of the key objects is once the Email Privacy Act by Representative Yoder and Graves gets to 218, you have a catalyst, and the catalyst is going to force something. And I side on the fact that catalyst is going to be at least pushing through Ecpa reform past the House committee, and then after that you have both bills that can actively go to the floor. I would also say you've seen Congress work together on things that everyone likes, right? Like with patent reform, it's something that congressmen actually agree on, and we're seeing in the Senate and the House move on those issues. I think email privacy and Ecpa reform is also one of those things. I think it's one of the few items where you have agreement across the aisle. You have agreement that it's an outdated law, and you have agreement that something needs to be done. It remains to be seen if that is 100%, if that's 99%. But I think that especially with kind of the speed as to how it's progressing in the House and Senate.
And especially if the law enforcement isn't pushing as hard against, I think that takes a lot of the pressure off.
Yeah.
Did you have something else, Dominique?
What I was going to say on your points, that you're absolutely right, that in terms of the class actions, we're seeing different cases being brought based on the different pieces of technology and the different disclosures that are made. So if a privacy policy says we're using cookies, but you don't disclose web beacons, we see almost an identical lawsuit coming against. So several companies have been sued 3-4 times in the space of a 10-month or 12-month period, involving basically a cookie cutter complaint with just different pieces of technology attached. What had been successful originally before the Ninth Circuit's decision in Edwards versus First American Financial had been a stance by the companies that Article 3, basically the plaintiffs did not have standing to be in federal court because they didn't have any injury in fact, whether there's back-end tracking that's going on for behavioral purposes to customize products or to serve ads. Was just not something that any consumer was actually harmed by. It's all on the back end, really. It's not something that many consumers don't even receive targeted ads based on it. It's customization that companies are using to develop product offerings and customize their websites that they're using this analytics for, and they're disclosing behavioral data for. It doesn't involve users' names. It's like unique identifiers and IP addresses. So that had been the argument, although the Ninth Circuit came out in the Edwards case in connection with RESPA, which is a real estate settlement act, and basically the Ninth Circuit said that where statutory damages are alleged, that is enough to show if the plaintiff alleges a violation of a statute that has statutory damages, that's sufficient to basically establish Article 3 standing. Since that decision, a number of the behavioral cases that I was mentioning, about 77 of them are here in California. And since that decision, courts have been very reluctant at all when there's statutory damages alleged, like under the Stored Communications Act, to dismiss those complaints based on Article 3 standing. And we're starting to see those same things happen in other states as well. So.
Okay, great. Nicole, did you have something to add or ask?
I don't think so.
Okay. All right, audience. What do you got? Oh, you don't have a mic there. You have a mic there, but it sounds like
The mic here. You might have to turn that one on, so just give it 3 or 4 seconds to turn on.
get some exercise this morning.
Okay, I like.
There.
Is it on? I'm out? Okay. I like Google, I like storage, I like Google Mail. Is it legal for Google to assist me at protecting my own privacy? The things I think about are, 1, can I ask Google to encrypt according to a public-private key what they store? Or could I ask them to move where they store it to what I call the Cayman Islands, which is illegal for the U.S. government to go into? I just don't believe the U.S. government obeys the U.S. government laws. So I want something that Google could do, or equivalent, to help me in isolating myself from that sort of infringement.
Well, the part of that I will pick up on is data location is a huge issue, and there have been a lot of requests from a variety of sources that think that data location is the solution to this, and it's not. Data location and requiring and making it's sort of a false construct to say that data is located really anywhere. For Google to work and provide the service the way you want it to, with latency, dealing with latency and resiliency and redundancy, and having something terrible happen where one data center is, not bring everybody down. Data needs to be distributed. Companies need to have the freedom to build their infrastructures in a way that makes sense for them and the technology and what they're trying to accomplish, and keeping the security and privacy of the data of the users at the forefront, of course. But putting the false restrictions on location is not going to solve the problem. And a lot of foreign governments are making sort of threatening these types of laws that they want the data there for sort of the opposite reason that you're saying, is they want to be able to access the data of who they claim to be their citizens, although even that sort of jurisdictional concept is very difficult to figure out in the internet scenario, how you decide whose jurisdiction a particular user falls under. So Google is not in support of any sort of regulations that force data location in certain places, or sort of create jurisdictional or legal rules based on the sort of even transitory location of data. And it's also wouldn't be a great idea for individual users to want to try to force companies to put data in certain places, at least not a company at the size of Google. It might be a niche sort of offering for some providers to do something like that and offer a service where their data is under the law and in the Cayman Islands or whatever. But for the types of services that Google and the larger providers provide, the flexibility and the ability to even keep that contract and promise, it would be very difficult to do, and is something that is probably not the solution to this problem.
Yeah, and I'll just add, I absolutely agree with what Nicole said, and this idea that you can safely put your data somewhere through a big company, I think is illusory. Generally, if the big company has your data, the U.S. government's going to go to the company and say, "Give me the data, and I don't care how you get it." So it's not going to be any kind of an excuse to say, "Oh, gee, the data's over here, I can't get it." So, and that's really true for sort of any country with which the U.S. has any kind of a relationship. So it's just practically not going to work. And what Nicole alluded to is maybe you want to go to some niche provider that sort of promises that they're first of all either going to provide you full encryption and or not going to collect any data. And there's some interesting cases of that, like there's the LavaBit case and some related cases. And then in the wake of the Snowden disclosures, there's some of those sites closed down. I can't remember the other one besides LavaBit, but LavaBit was under this tremendous pressure to LavaBit was run by Ladar Levinson, and they had everything encrypted, and they didn't collect metadata. They didn't, and when the government came and said, "Look, we need you to give us metadata," because LavaBit was the provider used by Snowden, and LavaBit said, "We can't do it." And there was this fight for several months, and it ended up that the government said, "Well, then just give us the key that unlocks everything." And Levinson ended up just shutting down the site, and they're now litigating that in the Fourth Circuit, whether that was okay or not. And so it'd be interesting to watch that case and related ones about whether a company sort of has the right to engineer itself in such a way that it can't cooperate with law enforcement.
Two things to add to that. The first one on encryption. EFF has long called and has advocated for Google to support PGP encryption. The unfortunate thing is you can't learn, at least from the company side, a lot about your user, right? If it's all ciphertext. But it's something EFF has pushed for and has advocated for ever since Google Mail, Gmail was invented. The second point is the location, data location. One thing that at least I've started to look into too is, you see some companies try and cater towards, if you store your location in X country, you'll have more protections. But one of the things, and Nicole might be able to talk about this a little bit more, but one of the tricky things are these things called MLATs, which are mutual law assistance treaties. And we've seen the government, so we just had we're talking about Ecpa, so we have seen the government in the past, right, use Ecpa as kind of a runaround to the Fourth Amendment to get the emails older than 180 days. MLATs are interesting because some MLATs, it's an agreement between two countries on law enforcement, law assistance, and how you can access data residing in the foreign country. And in some instances, you'll have MLATs with lower standards than the same protections you'd be provided if your data was in the U.S., right? Or if your data was residing with a company that treats your data as if it's in the U.S., wherever it may be in a data center. And so that's something to think about when you do see companies try and cater towards that, because these MLATs come up, and the U.S. has MLATs with a tremendous amount of companies. I don't know.
It's like North Korea and is the one we don't, and
maybe like Venezuela too.
Yeah, maybe like 2 or 3 countries we don't have them with.
So it's something to watch out for when you start thinking about it. Start thinking about this. Where data resides, because MLATs it's a very tricky subject. I know there's a lot of debate in the legal community about MLATs and the impact they have when a U.S. person's data resides in another country, and so it's something to watch out for.
And just on the civil side, I'll just say similarly, there are similar agreements between the commissioners, like the DPAs in the EU and the FTC, for example, work collaboratively on pursuing privacy issues, so that you would see that cooperation across jurisdiction now more and more.
Data protection authorities, yes. DPAs, yes.
Oh, sorry.
I wonder if any of your
we're making sure it's broadcast for the recording. Yeah, because thousands will watch the recording. Yeah.
I wonder if any of you had any thoughts about the recent controversy over Microsoft searching emails on its own servers that it was holding related to the trade secrets case, and whether you thought there were going to be any changes, or whether the new Ecpa regulations were going to affect searches like that.
You want me to start, or you want to start, Nicole?
You can start.
So I found that case really curious. One of the things that was curious to me was that the Huffington Post ran a headline right when that came out, and the headline was, "If this doesn't get you to stop using Hotmail, what will?" And it was such a strong reaction. And so my understanding is that Microsoft was investigating a guy who they thought was spreading its trade secrets to a blogger who was then posting it. And that's really dangerous for a company, because trade secrets are only protected if they're kept secret. And the minute they're disclosed, they're no longer protected. And so, Ecpa has some really clear provisions that say that you're not subject to liability if you are intercepting for the purpose of protecting your rights and property. The Stored Communications Act has a total carve-out for service provider monitoring. So I think I don't know if they were doing storage searching or real-time searching, but in other cases, I think they were pretty, I'm not giving legal advice and I don't know all the facts, so with that caveat, I'm pretty sure they were well within their legal rights. And so that was, so the reaction they had, and my understanding is they made sure to clarify their privacy policy afterwards, and they came up with this idea that from now on, they're always just going to refer that stuff immediately to law enforcement and not do it themselves. That's all about PR, in my view. It's not about anything else. And so what's interesting to me is that there was such a strong PR reaction, or such a strong negative public reaction. And I think that does show that the public's just much more concerned about privacy now than they were before, which is great news for us privacy advocates. I could be wrong about all of that. Nicole?
Yeah, I don't know anything that wasn't in the news about the facts. I think generally the view of people that know the law in this area is that it wasn't, putting aside contractual toss types of potential issues, that it was permitted.
Yeah, okay, I'm right about all of that. Yeah.
Permitted under the under the current laws, and the question now is should it be? I think it's a really tough issue to deal with, because there's a lot, there's other aspects of this where if you don't define what you're talking about clearly and precisely, it can become very difficult. I mean, there's one reaction to sort of the trade secrets IP type of issue. Then if you say it in the wrong way or too broadly, there might be questions about the ability to enforce your terms of service related to child exploitation issues. So there's a lot more. There's a lot to think about, I think, when you're talking about the service provider exceptions and the rights and property exceptions that are too hard to talk about.
Yeah, maybe it's too broad, the service provider exception. Rights or property could be really broad. Yeah, you had a follow-up?
I'm just thinking about, I completely understand the service provider, that service providers should be allowed to an exception, but it seems if you've got service providers that have conglomerates that do huge numbers of things, so that Google provided email services seems very unrelated to the self-driving car. And it seems funny that they should be able to use sort of concerns about other parts of their business to carve out the service provider exception.
Okay, I'm just going to repeat your question for the thousands who are going to listen to the recording. So you're concerned about the service provider exception being used, for example, for a self-driving car concern by Google, which is a conglomerate, to search email. You're concerned about that the rights and property is so broad that you could have this concern generating a search, right? And that's actually a really important question in the Gmail scanning case, which is right now the Gmail scanning case and the interception, they're trying to interpret interception, and there's a carve-out for using a device in the ordinary course of business. And there's two split decisions there on a motion to dismiss on whether the ordinary course of business for Google should be just Gmail. And Judge Koh said, well, ordinary course of business is getting that Gmail going. And you don't need to scan for Gmail, right? For Gmail, you need to just send your Gmail. And then the other judge saying, and I can't remember the name of the other judge saying, well, actually, Google is a platform. And Google needs to do targeted advertising to run its platform, right? And so this whole question of how do you define the entity when you have Google that sort of does everything? Sorry, Nicole, but it does. Is a really important question the law will have to figure out. But it is, I think, and this is something Nicole just said. It's what does it mean you're protecting your rights and property? And maybe that is something that we could look at reforming because it's a very, very broad term, and particularly with companies being so big, can they search for anything? And so I think companies can, again, limit themselves through their contracts, and they can, and as part of PR moves, limit themselves, as Google has done. I mean, as Microsoft has done. I don't think we'll see a movement in Congress, because in my experience on digital due process, which I alluded to earlier, you need the companies behind the reform to make it happen, and the companies are not going to push for that reform. So, hate to be cynical. Very true. Okay, it's your turn.
No comment.
Thanks. Hi. Thanks for this fascinating discussion. I'm the founder and president of Startup Online Creative Commons licensed World University and School, which is like Creative Commons licensed Wikipedia with CC with MIT OpenCourseWare. So looking ahead, I'm curious if any sort of the regime of Creative Commons licensing will inform sort of the upcoming sort of shape of the bills taking place on the Hill in any ways. And also, Nicole, in terms of Google and a global company, World University and School would like to have law schools in all 242 countries online if we could. Similarly, Google navigates in a global environment. To what degree does perhaps Creative Commons licensing, but also having a law school that could define, maybe through faculty, some of the interrelationships between countries in terms of law, might that have help with navigating, say, Google's issues?
I'll go first. So I think that, one thing when we discuss Congress is that they are far behind tech. Like they still think Facebook is a startup, I would say. So the one thing is, with that being said, I think they're just learning, right? They're just being educated on CC licenses and what that is. We've seen CC stuff and more of the open access movement hatch open and or grasp a lot of the congressional reports, and there's a FASTER Act. There are acts trying to push for, at least when it comes to academics and when it comes to government reports as well, if it's publicly funded, the research should be out there, right? There's no reason why publicly funded research shouldn't be behind a paywall, by a publisher's paywall. And so, that's kind of the context of where CC comes in. That's the context where CC comes in.
I'm not entirely sure what the question was with regards to Google, but I think definitely U.S. companies, or probably any company operating globally, it's incredibly challenging because of the difference in legal regimes in all of the countries in which you operate, and the fact that you, as a U.S. company, you still need to completely comply with your legal regime in the United States, and then dealing with the variety of issues that come up with hosting content that is accessible around the world, dealing with legal requests for information about users and information about who posted content. All of this is very, very difficult given that the laws are not in tune. And even though there have been some efforts to create some consistency around how these laws operate, it really hasn't yet come to fruition. It makes it very risky sometimes to be as innovative as companies would want to be, and to be as open around the world as companies would want to be, when you have to deal with sort of the regimes in different countries being so different. And one issue can then have DPAs in 50 countries investigating you at the same time. Or you finally finish one, and then the next one comes in, and it's all in the same issue, and it goes on for 10 years. And these things are really difficult and I think particularly difficult for smaller companies that don't have the same resources and don't have offices around the world and lawyers around the world and policy people around the world to deal with. It makes it difficult to innovate and puts up barriers to entry that are unfortunate. So I think it would be very helpful if there was a way it's pie in the sky, sort of a law of the internet, but it would be very helpful.
Very good. Okay, thanks.
Quick comment on that. We have our own differences among states too, and so there's that too. Question about Ecpa reform. We usually hear about Ecpa in the context of email, but the younger kids have moved on past email and they're communicating via text. Would the Ecpa reforms impact text messaging as well and protect texts as well as emails?
Well, this deals, so, one of the things I also like to point to, email, that's true, right? You have a lot of people using like Twitter, direct messages, DMs, I don't know how many people are on Twitter, and private Facebook messages and things like that. The kind of catch is that the SCA deals with and falls under the ECS kind of RCS distinction that.
Yeah, spell that out. Electronic Communications Service and Remote Computing Service.
Thank you.
Yes. These are terms that Congress came up with in 1986. And Electronic Communications Service was, the big companies were providing some email, like IBM was and stuff. And then Remote Computing Service were the companies that were doing, they were like the timeshare, because computing service was so expensive that anyone who was doing a lot of email, or at that time a lot, had to offload storage to these data centers. So this is something unfortunate for me. When we first started talking about Ecpa reform seriously, the idea was to keep the RCS-ECS distinction, even though that's the hook that the Department of Justice uses to argue that if you don't provide email to the public, the email on your system, once it's opened or accessed, is no longer protected because it can't be a remote computing service, because those have to provide email to the public. So I would love to get rid of that distinction, because I think there's been a lot of harm under it. But the reform effort has sort of taken the position, and I think this is based on a lot of experience, that when Congress makes a change to a bill, they want to make the fewest words possible changed. And that's just a value. And so what they have done, I know, and I'm going to give it back to Mark in a second, is is they've taken this weird definition of electronic storage out in these reform bills so that now it's an intuitive understanding of electronic storage, but they have kept RCS, ECS. Back to you.
Yeah, and so it hinges on the ECS, RCS distinction. I would think, things like Snapchat, private messages on Tumblr, Instagram, and things like that, would be covered. And so that's kind of how it comes into play. It's really any private online message, right? It's a message that you don't broadcast out. It's a private communication.
So the privacy protections would extend to.
Okay, so I think what Mark's saying is if the message is open to the public, there's an exception under Ecpa for things that are open to the public. So if you broadcast something on Twitter, it's not going to be protected, right?
Yeah.
That's what you're saying. But if there's something that's stored, so the definition under the new laws is if it's stored by a provider and it doesn't fall into the exception of you broadcast it to the public, it's likely to be protected. Okay. Yeah, probably one or two more questions. Yes.
Hi. My question is again going back to the core issue of privacy. So the question is, does the ECPA only apply to, say, US citizens or residents? Because then what it means is, what is the requirement if a US investigative agency is investigating someone who is not a US resident or someone who is not a citizen? Would you still insist on a warrant in that case by practice, or could you still insist on a warrant, or how would that work? Because that affects privacy of someone who's not even a citizen or resident here.
Is the person living abroad or living here?
Living abroad. But say everybody uses Gmail, right? So
yeah.
How does that work? Is that contemplated under the ECPA?
Yeah. You want to take it, or you want me?
I'm
definitely
just curious about the practice. Though.
In practice, I think that most of I don't want to say most of the providers. I know Google's practice is we're a U.S. company. Therefore, we, regardless of where the data is and regardless of where the user is who is using the service, Ecpa applies to our processing of requests for data that falls into the definitions of Ecpa. And I think the way some companies maybe do it differently and I think actually Yahoo is changing this, but is providing the service under a different, they might provide their service in the UK under UK law, under a terms of service that says UK law applies, and then it's more of a consent theory than an Ecpa doesn't apply. So I think, and Google, at least at the moment, provides the Gmail service and all of our content-related services from Google Inc., the U.S. company, and apply Ecpa across the board to all of it.
It's incredibly complicated, and thank you, Nicole, for that. Just a little bit to add to the complexity. First of all, if, as Nicole said, it may be that the local law applies, and the local law may be much better, much more protective of privacy than Ecpa. So European laws are generally more protective of privacy than U.S. laws. So you may be better off under those laws. And also for Europeans, we have these cross-transfer data transfer laws again that may be more protective because we're supposed to abide by certain when we transfer data over, or when we process data of Europeans, we're supposed to abide by some cross-border rules. But the one thing to be clear about is that the Fourth Amendment, which is ultimately sort of why law enforcement should require a warrant in some cases, Fourth Amendment has been held not to apply to non-U.S. persons in the Verdugo-Urquitez case because it was interpreted, the Supreme Court interpreted the person in the Fourth Amendment to be a U.S. person. So it's either a citizen or someone with sort of a longer-term interest. And so Ecpa is a statute which can do more than the Fourth Amendment, but ultimately the Fourth Amendment does not extend out past U.S. persons. And then there's also just the question of jurisdiction. So it's complicated.
I had one other question, which is that, so just to give you some background, I've practiced technology law in India and for a number of technology companies. So that's where my earlier question came from, and that's where my second question comes from as well. So what is the effect of a company here saying, for example, that I'm not going to comply with this because there is no warrant? again, for further background, in India, many companies would think twice about saying it in so many words or in such a direct way, because the law is still evolving, and you want to be engaged with the agencies of the government, because you want to be a part of process that determines what the law is going to be. You don't want to alienate them completely. So here, how do you deal with that kind of a situation?
We maybe don't have the same level of concern, I suppose, about in terms of I mean, nobody wants to have bad relationships with governing agencies, but there has been, the fact that all of the providers have said that we require a warrant. Really, the solution is to go to court. I mean, they can take us to court to compel us to comply with their subpoena, and then you fight about it in court. Is the way that, and so far they've chosen not to do that in the post Warshak era, and so that's how we've gotten to the point where we're really, even without Ecpa having changed, all the providers in the U.S., at least requiring search warrants, has become the status quo. But if the government would decide to push that by trying to enforce a subpoena for content, that would be the way that it would move forward.
And I'll just say, I don't know that all the companies require. I mean, maybe you know more than I. I mean, I think
there's so many. I mean, the major providers.
There may be some that don't and don't tell us, right? So. And sometimes, and not every company, I mean, many companies obviously don't have Google's clout and aren't willing to push back, and it is expensive to go to court. And, Twitter went to court over the disclosure of tweets in this Brooklyn Bridge case and lost, so in our country, there's some pushback. It's not automatic. And as Nicole was alluding, there was less pushback before the Sixth Circuit case. And one of the things that's interesting to me is historically, and this goes back all the way to the CALEA law that was passed in 1994, and I wrote an article about this in 96, Congress sort of says that the providers are going to provide this very important privacy protective backstop, and that as long as the providers can get in there and, be asked for the data, that they're going to stand in the shoes of the users and push back. And I think that makes an assumption that, as you're, alluding to, doesn't always happen, because the providers also are very interested in working cooperatively with law enforcement, particularly because providers are victims of IP theft and hacking, and so they are and can be prosecuted themselves and don't always have money to sue. So this whole idea that that they're always going to stand in for the users is a really a new phenomenon, and I think that has been accelerated by the Snowden disclosures, but in the past not true at all, or much more true on a spotty basis. But if you look at again what Congress says, like, hey, we've got the providers here, so who needs the users? Because we're hearing from the providers, or we're making sure that the providers stand in the way there, and so everything's great. And I think that's just something to be real careful about, particularly if the providers don't have to or can't tell users that they're giving their information away.
Yeah, one of the, a key aspect of codifying Warshak is to make sure every company is actually requiring a warrant. Really, we've seen a lot of the California companies take after Warshak, and a lot of great internet companies take after Warshak and require a warrant. But every year, EFF releases a report called "Who Has Your Back?" And one of the questions we ask these companies and ask the major companies who are ECSs, RCSs, is, do you require a warrant? And there are still companies that will not answer or have not publicly said that they require a warrant. And you can assume what you want from that, and it's a dangerous thing.
And I'll just, kind of jump into just on the international side, because on the civil side, we deal with a lot of international authorities, and particularly in India, because you have your new data privacy directive, and not that new, I guess 2 years old now, but there are a lot of jurisdictions, a lot in Brazil, I'm thinking of Germany, that are the government is actually very protective of privacy, so that there's not necessarily the polemical situation where you have the government rushing in and wanting to sort of trample over privacy rights. It's sort of the opposite over there. And I mean, I'm thinking of India and Germany in particular, where they're more protective of privacy than sometimes even the private citizens are. So I think it really depends on your jurisdiction, and to your point, when companies are working across global operations, just kind of knowing who you're negotiating with. It may not be a polemical thing at all. You may not be pushing back at all to say we will require a governmental order because the government will agree. Yeah.
All right, well, thank you so much. So I think we're going to give you guys an actual 10-minute break as our gift to you. And thank you very much.
Thank you.